We're keeping close tabs on two high-profile federal trials for you tonight. We'll start in Minnesota. The prosecution is nearing the end of its case in chief in the trial for the three former Minneapolis police officers charged with failing to administer aid to George Floyd while Derek Chauvin kneeled on his neck. One of the final prosecution witnesses today was an FBI agent who reviewed at least 12 videos and helped prepare transcripts of who said and did what at when that is, at the scene. Veteran prosecutor and BNC legal contributor Paul Henderson is back with me to help break things down and for a look ahead. Paul, I want to talk about something that came up in cross-examination. The defense tried to pick away at the credibility of those recordings by, among other things, saying that two people can listen to the same thing and come to very different conclusions. The defense also specifically addressed a part of the video that came up in the state case where the defense said George Floyd could be heard saying, "I ate too many drugs," something the prosecution and many others have challenged. What is your take on this strategy? Uh-oh. Paul, signal frozen. All right, so we're going to go to break and see if we can get Paul back. Welcome back to Making the Case. Before the break, I asked Paul a question. Paul, glad to have you back. This is what happens when we host a show from home and we've got internet connection issues. All right, we're back up and running again. Paul, I'd asked you about what had gone down on cross-examination, that the defense tried to pick away at the credibility of those recordings by, among other things, saying two people can listen to the same thing and come to very different conclusions. And the defense also addressed a part of the video that came up in the state's case where the defense said that George Floyd could be heard saying he ate too many drugs, something that the prosecution and many others have challenged. What is your take on their strategy?
I was disappointed with both of them. The first of which, saying that there are two different ways to look at the same thing. Yes, that's possibly true. But in a case like this, it is offensive when we all get to see the video. And they saw the video and they saw different angles of the same video. There is no two ways about it. There is only one conclusion, I believe, that you can get from watching that video of watching a black man murdered unarmed in the street like that. That is what you take away from it. And so by focusing on the possibility of maybe that's not what you're seeing, maybe what you're seeing is him knitting a scarf and getting on an airplane somewhere. That is ludicrous and it's insulting, which leads us into the second pick-apart challenge that the defense brought, saying that he was saying that maybe he had ingested some drugs. Again, this is a denigration of George Floyd. It's an insult to him as a victim, and there's no ambiguity as to whether or not he's a victim because the court has already found that he was murdered. He was a victim. And so trying to talk about whether or not he had some drugs, whether or not he was struggling or had the potential to be more violent is a distraction from actually what took place on that street, on that day that was captured on that video. It's insulting to George Floyd. It is not a real strategy. It's ridiculous that the defense is bringing this to try and distract the jury from focusing on the truth and what the real issues are. That's why you'll see rehabilitation from the prosecution to remind the jury of what the issues are in this case, that those officers should have acted either to prevent the officer from abusing George Floyd by the way he killed him, and or they should have acted to protect George Floyd, even though he was a suspect. There are boundaries on that behavior, and that's the issue. Everything else is a distraction from the defense, and they're insulting distractions at best.
Well, Paul, today we learned that the court will be in recess next Friday. The attorney for one of the defendants, Thomas Lane, is Earl Gray, as you know, and he's also the defense attorney for former Brooklyn Center officer Kim Potter. Now, next Friday is her sentencing date. Jurors were not in the room for these discussions, and they're not supposed to be watching any TV coverage related to the trial. But if they do, might jurors raise an eyebrow if they find out this attorney already represented another officer who's been convicted in another black man's death?
I think so. If they already know, this is likely the kind of information that they'll figure out or piece together after the trial is over. But any of those that are watching these cases, as you and I do in our lay positions, just in paying attention to the news, and specifically in paying attention to what happens with race impactful cases related to law enforcement, how could you not know? How do you not recognize him? How have you not seen him before? And maybe it's a possibility and they aren't paying attention to the dates and they don't know why he's gone. Likely, this is going to be information that they find out afterwards and then they connect the dots and have hindsight. And hopefully, this won't affect what they're considering as they're evaluating the evidence in this specific case and just are able to interpret these facts and come up with a conclusion and give the court a verdict and the rest of us a verdict.
All right, let's move to Georgia now. The end of a full week of jury selection in the federal hate crimes trial for Travis McMichael, Gregory McMichael, and William Bryan. This trial, as you know, focuses on charges that accuse the suspects of targeting Ahmaud Arbery because he was black. We know that 64 prospective jurors will return on Monday for more questioning before the striking, or better yet, the deselection process begins. They need to get the pool narrowed down to 12 jurors and 4 alternates. How will the questioning change in this next round as both sides begin the deselection process, Paul?
Great question, because this is where the metal meets the road. So what they're going to be doing at this level, and it's going to be really important, is they're going to be trying to evaluate from this pool really subjective interpretations about specifically race. They are going to be asking a lot of questions and looking thoroughly through any questionnaires that have been filled out by this jury about what their feelings are about race. Because in this case, right, this is the hate crimes. So they have to talk about and they have to prove from the prosecution that the crime was motivated because of something in a protected class. And in this case, we already know that the crime that was committed is a murder. And the protected class in this case is race. And so all of the questionnaire, all of the questions are going to try and unpack and uncover what people's familiarity with race is, what their opinions about race are, because they are going to be called to evaluate the motivation for these defendants in the context of race. That will be the singular focus, I believe, in leading up to who will be selected for this jury. And that's what we'll focus on all of next week.
All right, so the judge expects opening statements to begin again Monday, instead in the afternoon instead of Monday morning, because both sides are going to be finalizing the jury in the morning, and both sides also made it known that they would need probably about an hour. So with the jury being finalized, with opening statements happening in the afternoon, no witnesses are going to be called to the stand that day, so that gives the jury time to reflect on what both sides laid out. What are you expecting to hear from both sides?
I'm expecting the prosecution to talk about race. I want them to really make it clear that this is a case that didn't happen because Ahmaud Arbery was young. This wasn't a case that, although that could be a protected class depending on the context, that this didn't happen just because he had done anything, that they are going to try and polarize and focus this jury on race almost immediately. And I think that they should, and they have a really strong case to make. I think defense is going to try and talk about anything and everything but race. The interesting thing will be whether or not they will present their case differently from how they presented their first case at the state level, which was rife with political and racial overtones that I don't believe that we will hear in this case, because those stances will be held against them as they were likely held against them from the first case. But in this case, those predestined or pre-beliefs or prejudicial beliefs will be held not just against the advocates making the arguments, but against their clients, the defendants who are facing race-related charges for these hate crimes. And so it will be a different presentation, I'm hoping, from the defense. But again, it's all going to be about race. You will hear that word race brought up from both sides all day in the opening argument.
All right, Paul Henderson, thank you so much for your brilliant insight, as always.